everybody. It's really good to see you. My name is Jai Massari. I'm a co-founder and the CLO of Lightspark. I'm here today to moderate a panel with some really good friends of mine about corporate monitors in crypto. So the recent DOJ and CFTC, FinCEN, OFAC settlement with Binance included a requirement for Binance to have 2 independent corporate monitors. The estimated expenses for Binance of having these monitors is probably around $100 million. That is a lot. And so this is a really important topic to crypto firms, both in advance of any potential issues that they might face, but also as they think about how to deal with potential enforcement action, with potential litigation, in thinking about how to preemptively address monitorships, the potential risks of having a monitor, and then if you end up having a monitor, what that really means, and how to navigate life under a corporate monitorship. My panelists, I'll introduce them very briefly and then we will just get started. To my immediate left is Renato Moriati. He's a partner with the law firm of Bryan Cave. Next to him is Dorothy Dewitt. She's the co-founder of Tolt Strategies and a former director of the Division of Market Oversight for the Commodity Futures Trading Commission, that is the CFTC. And then last but not least is Kevin Mosley. He has a really long title, so I'm going to read it. The Deputy Chief of the Bank Integrity Unit, Department of Justice Money Laundering, Laundering and Asset Recovery Division. In short, he's a prosecutor, a very senior prosecutor at the DOJ, and actually participated in the Binance settlement that I just mentioned. So first, I'll turn it to Dorothy. Dorothy, maybe you can describe a bit of the background and context for corporate monitorships, not necessarily just in crypto, but more generally.
Sure. So corporate monitorships have been around a long time. Let's start a little bit just baselining with some lexicon. An independent corporate monitor is usually someone who is appointed, required to be appointed, has a company around them, they might be a law firm, but they're an individual, usually, that the government has required be appointed for a period of years with a set of responsibilities and usually a set term to ensure that whatever commitments have been made in resolving a regulatory enforcement or enforcement action actually take place. They usually advise and they usually test and they validate to make sure that what has been committed to is happening over time. The corporate monitors the government requires them in an enforcement action, and usually the company will choose maybe 3 options that are qualified based on what the government indicates are the qualifications required. And then those are proposed to the government, as in the case of Binance, and assuming that they're qualified, the government then chooses which of those 3 to utilize. We can talk a little bit more about this, but when Binance pled guilty in November 2000 last year in the Western District of Washington, Binance and the CEO, CZ, pleaded guilty. Binance paid approximately $4.3 billion fine, and CZ paid approximately $50 million fine, has since been sentenced. And part and parcel of that was the appointment of 2 different monitors. Often there's one monitor or one person or group that acts as the monitor in both capacities. In this case, as you know, we may hear a little bit more information today, but as reports suggest, in fact, there are 2 monitors. One is for 5 years, which is for the civil agencies, the CFTC, OFAC, and FinCEN, both part of Treasury, and that can be extended by a year. That's 6 years. That's about as long as Binance has been around. And the second one is a DOJ monitor, and that's for 3 years, also extendable by a year. Zai mentioned kind of estimates are about $100 million in total. Those probably go up markedly when you have 2 monitors instead of 1. And it's very invasive, it's very this experience is incredibly challenging for companies. And so I think everyone on this stage would prefer that you and your company never, ever, ever have a monitor, because you have done everything correctly and you've remediated whatever problems you've had, and you've avoided and deterred and detected and prevented all kinds of problems. But if it is on the table or becomes on the table, this is what this panel is going to talk about: how to think about it, how to select the 3 you might propose to the DOJ, how to work with the monitor as effectively as possible, because things can go really south really fast if you're not doing it effectively, and it can be incredibly challenging. Or they can go fairly. That's about probably the best you can ask for. Fairly, responsibly, and you can utilize that situation very, very well by turning it into a competitive advantage. And some finance staff have talked extensively about how, as painful as this process may be, they're going to really make sure that their processes are very clean, and they'll come out the other side in a much, much better position than their competitors in the industry.
Well, that's a really good point, Dorothy, in selecting monitors and thinking about monitors. But before we go there, I think a lot of us look at that $4 billion fine as the end of the settlement process. But when there's a corporate monitorship in place, it's not really the end of the litigation process. Maybe you could describe a little bit what a corporate monitor actually does day to day or in general as part of the core monitorship duties.
Sure thing. So once a monitor is appointed, proposed, selected, the agreements and remits are all in place, they know what they need to do, because what they need to do is outlined in the plea agreement. If you look at the Binance plea agreement, you can see dozens and dozens, 50s of pages of what the company is required to do, a bunch of mitigation, remediation, filing of suspicious activity reports and various other things. And it's really detailed as to what the company has to do. And so big picture, the monitor does a couple things. First, it says, all right, here's what the company has to do, and there are certain deadlines, and I'm going to verify and validate that that is happening, that that's happening timely, and that that's happening appropriately and effectively. And I'm also going to advise. The plea agreement that reflects the monitorship provides an advisory role for the monitor, which is not uncommon in frontier industries like this that get monitorships, where there may not be as much sophistication within the organization on best practices. So that's what the monitor does. It meets with the company and everyone there if they want to. It reviews any and all documents, incredibly invasive. It demands things all the time, which are hard to put together succinctly and in a form that's usable. And it meets with the government regularly and files reports with the government regularly. And so the government may say, well, we're really worried that we're finding lots and lots more SARs from recent activity. And the monitor might be able to indicate that that's because they're detecting more, not because more are happening. Or over time, and maybe there are fewer, but that's because they're preventing more because the changes made are working well. That's hopefully how it works.
Right, and just to point out something that probably is obvious to most of you, most crypto companies are not used to operating this way, right? We're all used to having quite a lot of latitude in deciding how we run our business, how we run our compliance programs, whether those are subject to regulation or not. Yes, getting examined from time to time, but I think the takeaway is that these corporate monitorships are much more invasive. It's having personnel that are not directly working for your company, but instead are watching over and providing oversight of your company, sitting in your compliance department, sitting right next to the business people, really reviewing your compliance activities against what's required by the government. Babysitting might be a pejorative term, but I think it is a lot like that. It is a way for the government to make sure that a company is actually going through with what they're required to do under a litigation settlement. So Kevin, maybe I can turn it over to you for a few minutes to talk about the circumstances under which you might seek to require a corporate monitorship. What are the kinds of cases that lend themselves to corporate monitorships? When are they required? Knowing this is quite a substantial burden for a company to sort of agree to as part of a litigation settlement.
Sure, happy to step in. Thanks for the opportunity to come speak to you today and to attend this really wonderful conference. I have to do the housekeeping, the governmental housekeeping dance, which is that I am a representative of the Department of Justice, but any comments that I say here today are mine and mine alone. They are not meant to reflect the views of the Department of Justice, and like if you ever end up on the other side of the table from somebody like me, you can't say that joker Kevin at Consensus said X, Y, and Z and rely on that for anything. So just to get that out of the way, I think that the corporate monitorships are invasive and expensive in the way that you've outlined, but they are typically used in, fairly maturing industries that have a big and large effect on whatever sort of industry they're in. So if it's oil and gas and energy or computers, or in this case, the financial industry, in one sense, like having this monitorship be a possibility is a somewhat of a compliment. It's a sign of a maturing industry. Yay, you're a maturing industry. But the other flip side of that is that folks like myself and the regulators will be very much monitoring and watching what happens with these companies to make sure that they are not posing an overall danger to either the U.S. financial system or to things like U.S. national security in the case of like sanctions evasion and sanctions violations. So there's a whole series of memos, because the Justice Department loves memos, so there's a whole series of memos that outline the policies related to setting up corporate monitorships. And the two main considerations are the benefit to the company and to the public of having a monitor, and balancing that against the cost of the monitor to the company. One thing you said about the monitorship being a part of the overall sort of settlement, it is, and it's part of the resolution, but monitorships are not meant to be a punishment. They are, like it says in the whole document at the very beginning, that monitorships are not punitive, they're not a punishment. So no one's saying, well, we didn't give you this kind of jail time or this type of penalty, so instead we're going to impose a monitor. There are independent considerations for the imposition of a monitor, and there are 10 factors that the Justice Department uses to evaluate these considerations. I'm not going to mention all 10, but I will mention sort of 4 very important ones. Whether or not the company did a voluntary self-disclosure, and there are some rules and regulations about what an effective voluntary self-disclosure is, and I may mention that a little bit in a minute. Whether or not there was an effective compliance program at the time of the resolution. So even if, and look, one thing that I will say is that I'm not a regulator, I'm a prosecutor. So there's a lot of conversations about whether or not the regulatory environment is clear or not. I would say from a prosecutorial perspective, that's not something we care about. Like there are some baseline things like AML and sanctions evasion that we think are like, table stakes and are fairly and very clear as to what companies need to be doing. Now, there may be some people in a later panel that may disagree with this to some extent, but that is the position that we have. So if we're here and if a monitor is being imposed, there's a real serious problem. But if you have created an effective compliance program after the misconduct, that is something we consider as to whether or not you need a monitor. The other thing we look at is the pervasiveness of the criminal conduct. So if it's really bad, like you did it on purpose, it involved the CEO or like senior members of your management team, your compliance officer was involved, and it was like a ton of money, then that's going to lean more in favor of a monitor. And then the last thing is remediation. When you found the problems, did you clean it up? Did you pay restitution to the people you needed to pay it to? Did you invest in a compliance program? Did you fire the people who did the bad stuff? Did you come to the government and report it? Like all those things are things that we will look into. And if the balance of those factors suggests that, in the case of Binance, they hit almost all 10 of the factors in a very negative way, and so that was the reason why they ended up with the monitor, even though they did do a significant amount of remediation and they did cooperate in the investigation. Really, it was the pervasiveness of the conduct, the egregiousness of the conduct, the fact that it involved the CEO, and that there was no self-disclosure. We came to them to do it. But in a lot of other cases, well, let me back up for a second. So if we decide that there's a monitor going to be imposed, there's a whole series of like criteria. There's a committee that has to go up to the Deputy Assistant Attorney General, And in big, huge cases, like, it may go all the way up to the Deputy Attorney General, who's the number 2 in the department, to determine whether and how to pick the monitor. And so there's a whole process that we go through where we evaluate the monitor's capabilities and their expertise, and try to make sure on the front end as much as we can that their scoping is such that it will minimize the amount of expense to the company. Now look, it's going to be expensive and it's going to be invasive, but we try to minimize that as much as we can. Now I mentioned those 4 criteria earlier because those factors very much intersect with the overall corporate enforcement policy and lead into ways in which you can avoid a monitor in the first place. So one, again, is voluntary self-disclosure. You come to us, you don't have another obligation to report, you come before we come knocking, you have remediated, you fully cooperate with the investigation, and you do all of that as quickly and as soon as possible and in real time, and do it substantively. Then you do all those things, you can get a declination. You won't get a guilty plea, you won't get anything, we will decline to prosecute, or at least there's a presumption that there will be a declination. But if there's aggravating factors like egregiousness or pervasiveness, or you've done it more than once, your executives are involved, or you made a bunch of money on it, you may not get the presumption. But even if you don't, you can still get a declination if you do the VSD immediately, you do effective remediation, and you have extraordinary cooperation with the investigation, which means timely updates to the government, making witnesses available, producing relevant documents, and collecting and organizing and translating voluminous evidence. If you do all of that, even if you get a criminal resolution, you can get a 50 to 75% reduction on the sentencing guidelines. And even if you're a recidivist and you do all those things, you can still get a 50% reduction. It just won't be off the low end of the guidelines, it'll be off the high end of the guidelines. So I guess if you wanna not get a monitor, you voluntarily self-disclose, fully remediate, fully cooperate, and realize that it's never too early in the process. So yes, maybe the government knocks on your door already and you think it's too late to self-disclose. It's not. If we knock on your door, there's other ways to disclose. You can still disclose, you can still remediate, and it'll still limit your ultimate punishment. Even for Binance that had to plead guilty to 3 criminal offenses, their ultimate punishment got discounted because they remediated to some extent and because they cooperated with the investigation. So if you want to avoid a monitor, do all of those things. And really all I'm saying with that is you're going to do everything in advance that the monitor will make you do later. So if you can prove to the government that you've done all of those things and you don't need a monitor, then we won't impose one, because it's expensive for you. And again, this is my view, not the government's view, but we have to monitor the monitor and we have to do a whole lot of work with respect to that monitor. So if we can avoid that whole thing because y'all did the right thing, awesome, that's great for us. So I think sort of from a table setting perspective, that is what you can do to sort of avoid having a monitor. The last thing I'll say is on the self-disclosure piece, there are very vital whistleblower programs with the SEC, the CFTC, and FinCEN. If your company doesn't come to us to voluntarily self-disclose, maybe your employees might. So it's another good reason to voluntarily self-disclose.
Kevin, thank you. That was very interesting and hopefully gives people a really good sense of how the DOJ thinks about corporate monitorships. The DOJ, of course, is not the only federal agency that can impose monitorship requirements as part of litigation settlements. There's also the CFTC, the SEC, and others. One of our panelists, actually, the CFTC enforcement director, got stuck with travel delays, so he can't be here today. So Dorothy is going to outline really quickly some of the considerations the CFTC, another government agency, federal government agency, applies in thinking about corporate monitorships. And then we'll quickly, I know Renato, poor guy, has been waiting patiently. We can switch over to talk about some of the practical considerations. But Dorothy, can you just give us a summary of CFTC-related considerations?
Sure. So I was director of the Division of Market Oversight at the CFTC. A sister division is the Department of Enforcement. I am speaking on my own behalf and not on behalf of the current enforcement director who had hoped to be here, or the CFTC or otherwise. What I am doing is just summarizing recent public statements he's made, and I'm effectively kind of quoting, paraphrasing, just to summarize so that I can give you a sense of the priorities and policies that he would have described, I believe, if he were here, because they have been reflected in recent statements and speeches that he's made. So why does this matter to you, and why do we think corporate monitors are coming here? Not just because we've seen it in a few cases, and we may not see it for cases that are being kind of discussed currently, and not only because they're used in criminal matters, but also because they're used in civil regulatory matters like the CFTC, and because Ian McGinley, the Director of Enforcement of the CFTC, said, we are going, as a matter of policy, we're adjusting our policy to appoint more independent corporate monitors and to require admissions as a part of settlement enforcement actions. And he emphasized that last year there were 96 enforcement actions with $4.3 billion in monetary relief collected by the CFTC. That's before Binance, which is huge. He identified various enforcement actions, including FTX, Binance, which the CFTC's enforcement action was very meaningful in helping move that along, in my opinion. Celsius, Voyager, UkiDAO, other things like that. And you may not have noticed, but the Division of Enforcement has required monitors or third-party consultants in some of their recent enforcement actions. What is the difference between a monitor and a third-party consultant? Well, Ian described in some of his recent remarks that he sees the difference as two basic things. A monitor, which we've been talking about, is there to make a recommendation, to test, and to report to the government. A third-party independent consultant doesn't report to the government like a monitor. It comes in and it gives assistance to the company as a neutral sort of advisor, but otherwise the company can remediate and make the changes on its own. What's the difference? Trust, trust, and trust. The factors that were just described by Kevin are analogous to the factors that the CFTC and others consider, and they effectively say, like, are you able and capable of fulfilling the obligations that you have to remediate and to come into compliance and to redo your risk and control framework? So this matters not only because we've seen it, but also because the CFTC and others have said we're going to require it more going forward.
Thank you, Dorothy. Okay, Renato.
I'm unleashed.
You've been so patient. You've been so patient. Can you talk about some of the practical considerations when you're advising clients who are facing enforcement actions, threats of litigation, both in heading off the possibility of a monitor, or what to do to make life under a monitorship better and easier for themselves?
Sure. Obviously, and I'm saying this, obviously I'm presenting a more industry perspective here than a government enforcement perspective. Obviously, you don't want to be involved in an enforcement matter. You don't want to spend time with Kevin. Kevin's a badass, okay? You can kind of tell. Just look at that guy. You don't want to spend time across the table from him. Ultimately, your best bet is to try to make yourself a less attractive target for regulators. You want to make yourself someone who's not taking aggressive actions that are potentially going to get on their radar. You know, Dorothy mentioned something called SARs. Those are suspicious activity reports. You don't want to have those sort of things generated for the government. So part of it is trying to stay off the government's radar, trying to take less aggressive steps, being thoughtful about public statements, but also on the flip side, behind the scenes, developing, you know, they call it a culture of compliance, having, even if you don't have a dedicated compliance professional, potentially engaging with somebody on the outside, an advisor that Dorothy was mentioning, who can actually give you some advice, create a program so that, for example, your employees are trained, so that you have policies in place, so that you have procedures so that if, for example, an employee is violating those policies, there's some actual consequences for that employee. So ultimately, you want to be able to have something so that when the government comes knocking, you can point to this and say, hey, we had this effective compliance program in place that Kevin was talking about earlier. But a lot of times, of course, at least when I talk to clients, my clients aren't the ones who already have advisors, they're already contracting with Dorothy or others to try to provide those services. The clients that I get are typically people who are like, look, we were very busy running our business, And this is, we're already working 100 hours a week. We're stretched thin. We don't have enough people. We're just trying to make things function. And now the government is taking an extremely unreasonable position. And if you're in that circumstance, I mean, and this is because I said I'm an industry perspective, I do think taking your time right now is a good thing that you want to do if you are facing an enforcement matter. I am not quick right now to resolve matters with the government. I'm not self-reporting right now because we don't know what the administration is going to be next year, and we also don't know what the administration's views are going to be in the future. And these policies that we have in place could change. We've already seen that in the past. So I really think from an industry perspective, we really want a regulatory framework in place. That's probably not going to happen for 2 to 3 years. So candidly, I'm, at this point for my clients, I'm actually trying to stave off government inquiries as much as possible. And if I am litigating against the government, I want to create as much leverage as possible so that I don't have a corporate monitorship, because if I do, that's very invasive. And we heard about it a moment ago. It's not just the money that's spent, but it's also the fact that you have to run through a lot of your decision making through an external person who's reporting to the government.
I mean, that's, I think, a really great point and something that is, again, worth emphasizing, right? It's not just the fact that you're paying a big monetary penalty, which is a lot, but also that your new business activity will, in fact, be constrained because of the imposition of this corporate monitor. You will not be making business decisions the same as you did pre-monitorship, because you will have to explain everything that you want to do that's new or different to your corporate monitor, why that complies with the requirements of the settlement, and then have that corporate monitor again explain that to the government, because I think, as Kevin said, the corporate monitor is in fact a force multiplier, not for the company, but in fact for the government, right? To do a lot of the work the government would have to do to make sure that a company that hasn't had such a great culture of compliance is in fact complying with the requirements of a settlement order or a court order. Maybe I'll turn for a moment to a related and important topic to Dorothy again. Whether you are worried about a monitorship or not, or maybe especially
worried about what?
A monitorship.
Yeah.
When you're thinking about what to do in advance of a potential litigation or settlement or after, how do you think about choosing a corporate monitor? Like, what are you looking for? What are the issues? How does the process actually work?
Can I go a little before that and then move forward?
For sure.
As a company evolves and grows, it can go two paths. It's either not going to face regulatory scrutiny, or it is, and if it does, it can go different paths, one branch of which can result into a monitorship. So what I have been seeing as a recent trend, my company that I founded does independent corporate monitorships and third-party consulting, but also does the pre-work to avoid it. You either do one or the other. You don't do the both for a particular client. But I've been seeing a trend of really big companies in this industry, leaders in those companies, coming and saying, look, we've looked at this, we've spent a lot of money, we put together a good program, but you know what? Making sure that our programs are at the level of expectations of whoever the 5 or 6 different banking and civil regulatory agencies that may cover us, making sure our program will withstand regulatory muster, whoever they are, is really important to us. So I've seen a number of leaders in the industry saying, let's come and have it tested, have it validated, have someone who has been in this industry in traditional finance, do an independent review of it so that we can kind of move towards the path of avoiding problems and satisfying regulators. Each of these regulators, whether they're banking, CFTC, SEC, the Treasury agencies, they're used to a certain level of kind of a compliance, risk, and control framework that derives from an exchange model, a broker-dealer model, or a banking model, and those standards are high, and they're higher than what I think most of industry understands. So I see this trend of saying it doesn't matter who regulates us or what the clarity is. What matters is that we just set a program that has been independently tested and validated, and we've fixed anything that has been identified so that we can avoid that. If that doesn't happen, well, let's just say it this way. Any of those things can help reduce the likelihood of a monitorship using some of the factors that were described by Kevin a moment ago. And so any of that pre-enforcement work that you do can reduce the scope of the monitorship, can reduce the duration of the monitorship, can suggest that maybe an independent corporate compliance, third-party compliance person is better than a monitor that reports to the government, those sorts of things. So you want to think about how you can do that. And then if you're at the point where you have to propose either an independent monitor or a third-party consultant, then you're really going to want to look for someone who has private sector sensibilities, has been in the private sector, has developed products, has implemented changing regulation, and has a very practical view. I also suggest that it's very helpful to have someone who's been in government, who not only understands what government expectations are, some of which I just described, but also has like the credibility that derives from having been in a senior position and pursued their work thereafter, and can understand what commissioners and you know, your supervisors and others require. So I would look for those things. The Venn diagram between people who really know crypto and have been in the industry and the people who the government would accept it's a very small overlap. Yeah, and the government is required to also think about DEI and choosing among those three, and then you get even smaller. Yes, so, you know, I think those are the things that you want to think about. I'm only going to say this at a very high level, and I don't know the facts. So now we're going into slight speculative territory. I think in a perfect world, assuming it's true that there is a separate criminal and civil monitor for Binance, I think the hope was that one, you know, very credible group could do both, and nobody has to respond. I think 2 versus 1 is suboptimal. It's more expensive, it's harder, it's this, that, and the other. So the lesson to take away from that example, if it's true, is that when you're selecting the monitor, you really want to select a monitor that the government and different parties in this case are all going to be able to agree on. So you know, the company proposes 3. You may want to make sure that within that are real viable options to satisfy the government, but also work with you to achieve the goals of remediation and enhancements to the compliance program. Maybe with a crystal ball, you know, that would have turned out differently, but just use it as a sort of practical way of thinking about, do you want to choose someone who you know really well and may not pass muster from the government, or do you want to choose, you know, something from the other, and recognize that that choice is an important one, and people like Renato can help you decide that.
Yes, please. I was going to open it up. I was going to say, like, this I think is really important because and Kevin, I'm really excited to hear what you have to say about this as well, but this is like a real insight into at least how the DOJ thinks about interfacing with external parties with respect to compliance, with respect to really important questions around remediating previous, like, potentially quite bad behavior. And I think it's really important for us as an industry to carefully take these points into consideration, to be honest, not only when thinking about corporate monitorships, but more broadly when thinking about our compliance approach. So Kevin and Renato as well, happy to open it up for both of you to comment.
Oh, you want me to go first? Now I'm going to take the industry perspective again. From my perspective, as we said, there's a limited number of people that the government would potentially accept as your monitor. There are people who have credentials like Dorothy's, you know, people who have been a bigwig in government, who can, you know, bring that credibility, that know-how. You want, from that group, you want to talk to those people and figure out who is the most responsive person, who's the most practical and solutions-oriented person. That would be my perspective. Because you're going to have to live with this person. This is like when my teenager wants to go someplace, she's got to get mom to drive her there, okay? You are basically, whenever you need to do anything in your company, you are relying on that monitor to sign off. That means you want somebody who's going to be on top of things, someone who's going to be responsive, someone who's going to be practical, but also somebody who has the credibility to sell that to the government and make sure that the government is okay with whatever it is you're doing.
So I would agree with a lot of that. And I just have a little bit of a spin on it. I'm going to put the Binance example aside for now because I'm directly involved in that process, and so I don't want to speak to that. But with respect to, like, first, I agree with Renato that, like, the best thing to do is not be in a position to have us come knock on your door in the first place. So, you know, like I said, I'm not a regulator. I show up when there are crimes or when thoughts that there might be crimes. And so we're in a very different position than regulators. So don't be in a position to have us come in the first place. I think with respect to the process, now so the company typically picks 3 people, they submit it to us, we vet those people, we interview those candidates, and we pick one or we pick none and say start over, do it again. I think Renato and Dorothy were both right in the sense that we are trying to look for, and we actually want this, people who know the industry. Like, we don't want people who don't know what they're talking about, because then the company and the monitor don't talk to each other. And to the extent that, like, we don't want to end up having to, like, reinvestigate this thing ourselves, which is why the monitor is there in the first place, you need somebody who knows the industry. But you also need somebody who's sufficiently independent from the company that they're not just going to take the company's word for it. For us, again, we show up when there's a serious failure. So we assume there's a serious process failure, a serious culture failure, and other things. You don't just turn those things around on a dime. So you need somebody who's going to be enough independent to be skeptical about the things that the company says, but also being able to do that in a way that is practical and says, look, they can't do this right now. They said it's going to take, 5 years. It may not. It probably will take 3, but it will take a while. You need all those things. And again, that Venn diagram is not huge, but that's what we look for. But I think in the sense of looking for that in a monitorship, I would submit that, like, that is what you probably should be thinking about and looking for with respect to the people who advise you in the first instance as to how to set up your program and your processes. Because you don't want somebody who's just in the tank for you necessarily, because they might not set you up in a position to succeed. They may set you up in a position that you may have further regulatory problems down the road. Now look, everybody's got to make business decisions, and those entail a certain amount of risk, and what everybody's risk tolerance is up to them. But I would suggest that the same criteria that you would use to fix or to come up with a monitorship is the one you would use to come up with who your advisors are going to be in the first instance.
I mean, those are really great points, Kevin. I think my takeaway is choose your advisors wisely, whether those are consultants, compliance consultants, law firms as well, which often fill the roles of these monitorships. We have a very, very short amount of time remaining for the panel, so I just wanted to open it up to anybody for last minute thoughts. I think this has been really, really interesting, probably a little bit terrifying for some of us, but happy to open it up for any last thoughts.
I would just say that if you're not sure, talk to your counsel, and you can also bring in independent testing, someone who, a group, big or small, that can come in and just test where things are and can get sort of a sense of whether you need a lot more help, or if the testing turns out well. That's sort of a first step that you can consider taking.
Yeah, I think that's right, and I agree that having the right lawyer is very important. What you want is you want to have somebody who can be a real trusted advisor to you, somebody who is practical and has a practical approach to your business, sure. Understands your business, yes, but also has enough experience and understands how to navigate these issues with the government so they can help you avoid pitfalls before they start. It's a lot cheaper than dealing with this. I mean, I think you've seen that from the figures that we've been tossing around today.
I think the last thing I would say is that you need to be in a position to, like I said, avoid having us show up in the first place. And some folks decide, oh, we're going to avoid this by creating a structure that is not government, that is not regulated. That's very risky. I would advise against it, because your costs down the road could be very expensive.
Okay, thank you so much. This was really wonderful. Please give them a round of applause.